Chalo. FR versus DPSP. Fundamental rights are justiciable. So DPSP is non-justiciable, but we have said Article 37. What is the moral obligation of the state to implement DPSP? Okay, you are saying fundamental rights are justiciable, whereas DPSP is non-justiciable, but it is the moral obligation of the state to implement it. If you implement it, then somehow, because of the collectivism, somehow you need to infringe upon the individual rights. So there will be a conflict. Okay, there will be a conflict. Okay, there will be a conflict. So the first conflict came in the 1951 itself, regarding to the already told Champakam Dorarajan case, Article 15. It's a no discrimination and giving reservations to SC and ST in weaker sections, Article 46. They want to implement this DPSP. They want to implement this DPSP to uplift the SC, ST and weaker sections. But he claimed that if you are giving extra privileges to them, then you are discriminating. You are discriminating. Why Article 15 should not do it? What here it has been told? FR prevail, fundamental rights prevail over DPSP. There should not be any discrimination. So you can't do any reservations for SC, ST and weaker interest. You can't do anything. But if you want to do it, what you have to do? You need to change the fund. It can be amended. Got it? Understand? In 1951 itself, like if they want, when government thought of giving few reservations or what, few facilities to SC, ST weaker sections, the Champakam Dorarajan case, what he asked is, it is discriminating against us. You are giving more facilities to them and you are discriminating me. Okay, you are discriminating me. Under Article 15, then court has told that yes, as per the constitution, fundamental rights will prevail and government can't give any extra facilities to the weaker sections. But if you want to do it, what you have to do? You can amend the constitution. Accordingly, first Constitutional Amendment Act 1951, I clubbed it here. In fact, the fourth Constitutional Amendment 1955, 64 also, same thing like that. They added 15 subsection 4. I already read it out. Nothing in this article will prevent if I implement any activity for SC, ST weaker sections. Nothing in this article that means I can discriminate. If I am doing something for SC, ST weaker sections, then that discrimination is okay. The differential treatment is, I am giving differential treatment, but the differential treatment is to bring them into the equality for level playing field. That's what. So here what happened finally? Which prevailed now? DPSP has not upper hand? Okay, very good. Now Golaknath case in 1967 with judgment of 6:5. Out of 11 judges, 6:5. Marginally by only 1. In 1967, 500 acres of farmland. 500 acres of farmland. State government enacted 17th amendment to Punjab security, and what they have told, and they kept it in the 9th schedule. Why? To escape from the fundamental right. If you keep it in the 9th schedule, that law, it can escape from, as of, on that date, you can escape from the fundamental right. And accordingly they told, please give out of 500 acres by this act, ceiling limit is 30 acres agricultural land you can be having. So please give a remaining 470 acres. Remaining 470 acres. He went to the court. And told, right to acquire and hold property. Right to acquire and hold property is a fundamental right, and it has Article 19F, and it has been violated now. It has been violated now. Here, it has been violated now. So here what court has ruled? Fundamental rights can't be amended. Here I have amended, right? Thereafter it is in 1951, 55 and 64. Amended 3 times. Here I told fundamental rights can't be amended for implementation of DPSP. And here Article 368 was ordinary law within the meaning of Article 13(2). If you see what it has been told, I remember in Article 13, law means what? They told, no? I told you, what do you mean by law in Article 13? So that law means it is a normal ordinary law, not the constituent law. So as per this, you can't amend it. So in here they have amended, DPSP prevailed. DPSP prevailed till 1964. In 1967, which prevailed? They told fundamental rights. Fundamental rights can't be amended for the implementation of DPSP. So you can't take it right to property. Okay, so you can't take his land. Okay, that's why what government has done after 1967, in 1971 they amended. What they amended? Parliament power to amend fundamental right and amended Article 13 and 368. What they have written in Article 13 now? They can, I told you Article 13, I will just read it out. Yes, the definition of the law, and they have inserted one more. 13 subsection 4. Okay. Initially what they are told? Any law inconsistent with the derogation of fundamental right will be void. But why 24 Constitutional Amendment Act 1971? They added 13 subsection 4. What they told? Nothing in this article shall apply to any amendment of this constitution. That means I can amend anything. I can amend anything. Accordingly, I am supreme power. So I can amend anything. The meaning kya hai? I can amend anything means there is no judicial review. There is no judicial review. Till now any doubts? We are going ahead. Any doubts? समझ में आ रहे? हाँ? समझ में आ रहे? जा रहे? आ रहे. Good. Now, so from starting from the story of 1951, now we come till 1971. Okay, 24 Constitutional Amendment Act 1971. Again, one more Constitutional Amendment Act 1925 Constitutional Amendment Act. What they are told? Already I mentioned you. For implementing only two DPSP principles. What are those? 39B and 39C. What are those? 39B is distribution of material resources. 39C is prevention of concentration of wealth. To implement those DPSP principles, if government implement any law, then they can violate fundamental rights. That's what amendment. Second thing is already I told. Remembered yesterday. No law with declaration such policy I can't question in the court. I have been given the law, I can't question in the court that it does not give effect to such policy. So whatever I have been given in the constitution, I can't question him. I can do anything. Can't you question the court? And if you are taking the questioning power, what you have taken? Judicial review power. If I am unable to question in the court, what do you mean by that? I have taken the judicial review. So after 1971, in Keshavananda Bharati case, what happened? They told the first one is okay, I am agreeing for distribution of material resources to the people, welfare of the people, and for prevention of concentration of wealth. If you want to implement few laws, and if they contravene Article 14, right to equality, freedom rights, and right to property, Article 31, it's okay. But the second one is there, right? What is the second one? Can't question the court. You can't question the court. That is not okay. Why? You are taking the judicial review power. वो तो अभी बताया. Till now there is no basic future. Till now there is no basic future. You can't take that power, judicial review. Why? Because this is the basic future. फिर सबको समझ में नहीं आया. ये तो है ही नहीं constitution में. What is the basic future? Then our judge has told, like what he has told, those basic future means you can't amend. These are the basic futures you can't amend in the constitution. What are those? Like he has told few examples. One of them is judicial review. Thereafter few judges told, added few more basic futures. Democracy, independence of judiciary, secularism, like that, be now 50 to 60 basic features which can't be amended even by the parliamentary form of the government, like that they can't. These are the basic futures. Okay, till now any issue? So what they have told? Here you can amend. Here they told you can amend the fundamental rights also, but not basic futures. Now coming back to 76. Here they have invalidated in 73 only second provision, this one, and they are okay with this 39B and C. Now government got much more confidence. Okay, now court has told that it's okay while implementing 39B and C, I can violate fundamental rights. Now it has told extended Article 31C, this one, saying that any DPSP, not only 39B and C, between Article 36 to 51, basically among them 38 to 51. If I amend like based on for implementation of these DPSP principles, if I make any law, it can violate fundamental right, and if it violates fundamental right, you can't go to court. They are immune. Okay, immunity. So it's just like a vaccination pill de diya. Okay. So here what happened? Again, who will prevail here? DPSP, right? After 76, what they have told? I can change for implementing any DPSP principle. I can make any law and I can violate any fundamental right. So who prevailed here? DPSP. समझ में आया? Huh? Got it? Now, after the Constitutional Amendment 71, Keshavananda Bharati has taken over. After 76, 1980, Minerva Mills case. What they have told? Above extension. What is that? Any DPSP immunity, okay, is invalid. So now what is remaining? This 39B and C. For this you can do anything, but any DPSP is not good. That means if any DPSP means you are taking out blanketly my judicial review power. If you are taking out my judicial review power means my independence has gone. Okay, you can't do it that one. Okay, that means here who is prevailing? Fundamental rights. As on 1980, who is prevailing? Fundamental rights. But what he told, above extension is valid, but Article 14, 19 are subordinate to, he accepted again 39B and C is okay, for implementing them you can do it. Okay, and thereafter by that time Article 31, right to property, abolished. Okay, Article 31, right, because if you see here, they can contravene Article 14, 19, 31. By that time 31 is the right to property, is a fundamental right. In between 1978, Janata government has taken out that right to property as fundamental right. So remaining only 14, 19. So you can infringe upon these 14 and 19 articles. Got it. Thereafter, so and Minerva Mills case, what he has told is, so you should not think that which is prevailing or what. There should be a harmonious balance between fundamental rights and DPSP. So it should be the bedrock of balance between fundamental rights and DPSP. Together there is a commitment to social revolution, like two wheels of the chariot, because these are the actual few other words. There should be, so these DPSP goals should be achieved. It can be achieved without taking out the fundamental rights also. But in case of any requirement, you can take it out, that too to the extent of 39B and C. So finally, what is the final crux? As of now, what? Fundamental rights will prevail over, as of now, DPSP. And but you can't write it like that. You should be little bit reasonable. You can't say that fundamental rights are like that. They are. But at the same time, in some circumstances. Okay. But thereafter also you need to see even that sound. Okay. Thereafter also you need to see circumstances. They are complementary to each other. They are supplementary to each other. Because we have seen there like Article 38(2) at right to property, by giving that DPSP and fundamental right, because they need to supplement each other to provide equality to everybody. Okay. So but here what is the final crux? They can be, as of our present position is fundamental right will prevail over DPSP, you need to write that explanation. Even though they are complementary to each other, they should have a harmonious relation between them. Is the bed on base of the bed of balance, like as a foundation, FR and DPSP will be there. And finally, Parliament can amend anything except basic future. Okay, till now any issues, any doubts? Can I follow? Okay, proceeding. So what are the basic differences between fundamental rights and DPSP? Fundamental right means you don't do this, you don't do this. They are negative in character, prohibited from state doing. Whereas DPSP is positive, telling the government to consider these directive principles while implementing laws during legislative process. Okay, they are fundamental right justiciable, DPSP non-justiciable. Political democracy, social and economic democracy. Legal sanctions, moral and political, that means they are justiciable. Legally they are justiciable, but this is political sanction. Political sanction means if you don't implement, what happens? People will make you out of power by exercising their political vote. Okay, they are individual welfare, whereas this is society, community welfare. Here for fundamental, any legislation is required, no legislation is required. Whereas for DPSP, for implementing directive principles, you require respective legislations. Fundamental right, if any violation, law will be invalid. Here, please see. If DPSP violation, if there is a violation of DPSP, can you make it invalid? You can't, but it can uphold validity for giving effect to DPSP. If there is some little ambiguity, because constitution provision, everything can't written down. Like if there is ambiguity for interpreting the constitution, where you will see preamble. Like that also, if you are seeing any law and if you are implementing DPSP, you can make that law as valid if it is implementing, even though they are not justiciable. Like the preamble only, you can see what our constitutional maker, what is our noble vision. So if it is making the DPSP principle, then you can make it as a valid law. Got it? Paradox.